8 years, and very fortunate to be able to do that, and glad to be here with you tonight. To give you a little bit of background about me and probably why I was tasked with presenting this, a lot of my background in my 27 years in law enforcement has been around firearms, use of force training, and instruction. So some of the stuff that we're going to go through tonight, I've been tasked throughout my career with training other officers, and hopefully tonight what we're looking for, if not always agreement, just a good understanding, an honest understanding of what our rules are, what the laws are, and what our protocols are for use of force. If I get somewhere, and I know we're going to wait and take questions at the end, but if I say something and you're kind of like, what did he just say? Now, I have an accent. I'm from Mitchell County, and I can't help that part of it. But if I say something that is confusing in the way that I stated something, please raise your hand and give me the opportunity to fix it there, because it may be critical as we move in to some of the other parts of the presentation. First slide, Robin. Okay, North Carolina has a statute which oversees use of force for law enforcement officers, and it's 15A 401. And by North Carolina law, officers are granted the ability to use force in a couple of different situations. The first is to prevent the escape from custody or to take into custody, effect an arrest of a person who that officer, now here's a term you're going to hear over and over again tonight. And it's not one of those terms it's one of those terms that's open for interpretation, and it's reasonable. What is reasonable in the situation? It's what is reasonable that they believe that the person has committed a criminal offense unless they know the arrest would be unfounded or unauthorized. Next slide. And the second, and this one is where we get into a lot of the deadly use of force with law enforcement. It is the ability of an officer to defend themselves from a third person, what a reasonable officer would believe is presenting a risk of death or serious bodily injury to that officer, okay? Or to what they would need to do to effect an arrest while preventing the escape of someone who presents, they're armed, and by their activity, they present a direct, immediate threat to the community if they allow that person to escape. Now, you're probably going to hear some things tonight that you go, I don't necessarily agree with that, but what I will tell you, it is the law that we operate under. So, and I don't get any leeway in that. We kind of have to operate under those things and adhere to that. Next slide, Robin. When is deadly force authorized? It's really authorized under 3 categories in North Carolina, and one does not apply to what you would look at as municipal or county officers. One is really a DOC statute, and it's the last one, and we're going to talk very little about that, but it's basically, if you see DOC officers working on a road crew and they're supervising someone who has been convicted of a felony, and that person tries to run off and they're convicted and in custody, DOC has the ability to use deadly force. That really doesn't apply to us as municipal and county officers out here working day to day and answering calls. And the other 2 we've already worked about.
Tell us what DOC is.
Department of Corrections. That's the folks who are supervising people who are in prison. Thank you. That's exactly what I'm asking for you to do. We're the acronym people in law enforcement and government. So if we say something that's common speak for us and it's kind of like, what did he say? Stop me. The first use of force is to reasonably effect an arrest, and I'll get to some of the specifics of that, of someone who is guilty of, there's probable cause to believe they have committed a crime. That officer has the obligation to take that person into custody. They have the authority to use force, which is generally one step above, and what is accepted is one step above whatever the person who they're trying to put in custody is using against them, okay? So that doesn't mean if you have somebody resisting, you can immediately go to a high-level use of force unless that person's resistance and the factors around it substantiate to a reasonable officer what they would have to do to get that person safely into custody. The second is to what I talked about just a little bit earlier. If you have a situation where someone, by their actions and by their ability, or in other words, they have the means to do serious bodily injury or death in the community, and they're trying to escape, a law enforcement officer has the ability to use deadly force to stop that, okay? If it would be reasonable to believe that that person who's trying to escape might encounter somebody in the public, a neighbor, somebody motoring down the road, another officer they might run up on, that officer has the right to use deadly force in the state of North Carolina. Next slide. Now, this is a little bit about the training we get. Now, this is basic law enforcement training. For our folks who are coming into the profession, a lot of that training's done at AB Tech. Some of it's done at the Justice Academy where I used to work. And this is the bare minimum. There's a lot of in-service training. Every law enforcement officer every year has to have, this year it's 16 hours of firearms and that type of use of force training. Every year they kind of break it up and they'll do different uses of force, and we're going to get to what are those uses of force in just a second. But if you see an officer wearing a badge, sworn, they've at least had this, if nothing else, which is 620 hours of basic law enforcement training. 28 hours of that is on arrest, search, and seizure and constitutional law. Then there's subject control, we commonly refer to as SCAT, subject control and arrest techniques. There's a whole week of that, 40 hours of that. That's everything from unarmed self-defense to handcuffing and taking people into custody. And then application of the reasonableness standard. And that's generally what gets debated. And that's not just for officers, that's for when you see these high-profile cases come up in the media, generally most of the debate is around, was this person's defense in actually using deadly force on somebody, is that reasonable? Is that what the average reasonable person would have believed and would have done given the same set of circumstances? So, you know, you're going to hear a lot about the reasonable standard. Next slide. Now, we're going to talk just a little bit about our use of force continuum. Because a law enforcement officer wears a uniform, legally, if you were asking Frank or another legal mind, is presence a use of force? For really court and talking about it in those terms, it isn't. But in the terms of training for us, it is. Because if you have a law enforcement officer that's identified as an officer, when they show up and their presence becomes known, the whole cycle of events starts in that interaction. So we look at presence as being the first use of force. Demeanor, approach, and then we go right into voice command or verbal control. What I will say about that is we have come leaps and bounds over the past 20 years in how we teach officers to engage verbally. We do something called verbal judo. We do training and teaching in something called emotional intelligence, which involves self-regulation and self-reflection and realizing how you're coming across to people, whether or not you're being understood. We do a lot of training in those areas now. Used to, we didn't. And I'll be honest with you, some of the things we're living out of, 30 years ago, we generally tried to hire a big, strong guy who maybe had some military training, and we gave him a gun and said, go forth and enforce the law. Now, that didn't always have real good results for us, but it was probably the best we knew at the time, and a lot has evolved. So what I'm telling you is what would have been accepted as a good practice or best practice 20 or 30 years ago no longer holds water. That standard and what's expected of us in the use of force and how we interact is more scrutinized, and there's a higher standard expected every day as we move forward in this career. Soft, empty hand control, third level use of force. That's if I walk up as an officer and I talk with somebody and I have probable cause to make an arrest, and I go to effect that arrest and I tell that person that they need to turn around, they're under arrest, I have to handcuff them. when I get a hold of them and manipulate them physically in any way, in an escort procedure or moving hands back to handcuff, I am at that third level of force, okay? Now, if I have somebody that I'm talking with and I tell them they're under arrest, I communicate that to them, and I ask them to comply with turn around, putting their hands behind their back, whatever the situation is. If it's a pretty highly charged situation and that person has exhibited some violent tendencies, I may actually ask them to get on the ground, get on their knees. Why do you think a law enforcement officer would do that? To see what's happening, but as much as anything, to limit their ability to hurt that officer while they're handcuffing them. Because believe it or not, the last thing an officer wants, if they're a reasonable officer, and I'm not saying everybody is all the time. I mean, I don't know of a profession where sometimes the wrong folks are not in the right job that they need to be in, or they're in the wrong profession for their personality. But what I'm saying is, for a reasonable officer, the last thing they want to do is get into a physical confrontation with that person. Why? Because every confrontation that goes physical, there is a chance that the officer or the subject is going to get shot. Is every officer that a law enforcement officer engages with, or every situation an armed situation? It absolutely is. We brought the gun, right? So if things get out of hand, that officer loses control of the situation physically, there is always the possibility of that person getting that gun, and now you have somebody with the means to deliver deadly force in a very efficient way. So officers have to be very aware of that. The last thing we want to do is wind up down on the ground in a struggle with an individual. So we try to control that situation without having that happen, because that can have very negative endings for the officer and the subject. The second thing, and you guys, we're probably going to have different opinions on these next two things coming up. Chemical munitions, OC spray, and tasers. Because, and that is a fourth level use of force. That actually comes before we, in a perfect world, if a situation unfolds sequentially, like we have it laid out here, a taser or pepper spray should come into play before an officer ever strikes a subject trying to effect an arrest, okay? And it's something that we'll talk about in just a second, but one of the principles that we operate when we evaluate defensive tactics is the amount of control it gives the officer to put the person under arrest versus the amount of injury it can cause to the individual. So the better the defensive tactic is the one that offers the greatest amount of control so the person can be put into custody and not be hurt versus what might cause injury. Before we had tasers and before we had OC spray, once we went from soft, empty hands, the next step up was less than lethal intermediate impact weapons, which more than likely is going to be an ASP or an expandable baton. They're pretty effective, but they generally cause injury, almost without exception. So that's the reason why there's been a huge acceptance of tasers and OC spray in law enforcement. A taser, I've been tasered twice. There will not be a third time unless somebody shoots me and I don't see it coming. I'm just telling you. We experience those things, on one another. We have to be OC sprayed and we have to be tasered to be able to carry those things to understand the effect. I've been tasered twice. Somebody who can fight through a taser, I don't understand that. It is completely incapacitating, it is extremely painful, and it stops your motor activity and puts you on the ground immediately for 5 seconds. Now that sounds pretty harsh, but the great thing about it is it causes no permanent damage, and as soon as that 5 seconds is over, there's no lingering effect. You're good to go. You get, hopefully by that point in time, you can be in handcuffs and be moving to the car. And I heard something, I'm going to go ahead and take that on unless what? There are a few cases out there to where folks, and most of those have been attributed to something called excited delirium, okay? And do what now? When we get into totality of the circumstances, an officer that's a reasonable officer is probably not going to be tasering a pregnant woman. I can't say without exception that's never happened. I don't know that we ever have. It's a little controversial, but what the experts say in the field, who aren't all law enforcement people, is people have died because they have some kind of controlled substance going on, which raises blood pressure, raises heart rate, and they fight past the point of what the body can naturally stand. And a lot of times they will go into cardiac arrest. Happens very infrequently. What I can tell you is the severity of injuries before we had the taser to people who were fighting that we took into custody, they're much lower now with the taser than they were when we had to immediately go to a baton. So that's a good thing. And a lot of times, you know, we live in a world that's not a perfect world, but we look for the things that give us the least amount of percentages of causing damage. And that's one of the things that has. The next, fifth level use of force, intermediate impact weapons, that means that we use some sort of a baton, and actually strikes with fist and feet fall into this category. So if an officer is using a fist to strike somebody, they are at the same level use of force as an officer that would use a baton, okay, legally. Now, which do you think is more effective, a fist or a baton? Probably a baton, but you're at the same level of liability and use of force if you choose to use a fist. That's why you don't have officers, you don't see that widely anymore. Not that it's against policy and that we don't train for some of that, but that is a high level use of force. Now, if you strike with a baton in an area that could cause death, such as the head and the groin, and when we do training, we train, you know, those are things you absolutely stay away from. We work for larger body parts that are covered more thickly with muscle because there's less injury at the end of the day. But there's still nerves running there, and you can get a certain amount of compliance to get, because remember, the goal is to get the person into handcuffs, because then you can de-escalate the situation, and hopefully nobody's going to get hurt from that point going forward. And that's the goal. That's the good, reasonable law enforcement officer's goal. Not to hurt anybody, but to get compliance and get that person into custody with nobody getting hurt. And then lastly, you have deadly force. Now, we always think of firearms as deadly force, and that is, by and large, the largest use of deadly force by law enforcement officers. But when you talk about a subject use of deadly force, knife, impact weapon, where they've not been trained to hit somebody in the head with it, those things all fall into deadly force categories. And one thing that we're going to talk about tonight, and I wanted to expose you guys to because I think you'll really be surprised and you'll kind of be shocked. Handguns are really not that effective, and they are semi-lethal. In effect, they're lethal, but as far as stopping violent, aggressive behavior, they generally are not immediately effective, okay? And don't want to turn this into a ballistics class, but rifle ballistics and handgun ballistics are different. There's a difference around them. A rifle's much more immediately incapacitating. A handgun, in many cases, is not. Why is that important to the discussion? Because in many, many cases, law enforcement officers will shoot a suspect, and that suspect will go on to kill the officer or multiple officers before they succumb to that wound. It could be a lethal shot that's non-survivable, and that person could still operate up to 3 or 4 minutes after that, depending on their level of intoxication, their level of endorphins and things that are released because of the struggle. Gunfights are extremely dynamic, unpredictable events that if you really understand the dynamics of them, you don't want to be in one. I don't care if you're the best shot, you've had a ton of training, you don't want to be in a gunfight, and I'm getting ready to show you why. And I'm glad we don't have small children in the crowd because some of this stuff is pretty graphic, but we can talk about it all day, but until you see it unfold, it's really hard to understand some of the dynamics in play there. Next slide. Talk about a couple of the principles for use of force. We've talked about reasonable officer standard. I think you guys understand that. The difference in the officer and a civilian in a use of force situation outside a civilian's home is the officer has no obligation of retreat. As a matter of fact, they really don't have the ability to disengage except under certain situations. And what I mean by that is they have the obligation of handling the problem. So let's say we're out here, South Charlotte Street, wherever in the city you want to pick, and you've got a civilian interacting, and that civilian is armed, legally armed, and the person they're dealing with presents them with a deadly force threat, which means that a reasonable person would believe that that person was getting ready to cause serious bodily injury or death. That civilian would have to show that they had no opportunity to retreat and get out of that situation before they could use deadly force. That's different for a law enforcement officer. Other than that, much of the rules apply, whether you're a civilian or an officer in that use of force, okay? Totality of circumstances. If I have Robin Michaelov, who's awesome and she's great, but if me and her are going to effect an arrest, I'm 6 foot 240, she's 5'3", and how much you weigh? Boy, she'll kill me after, but how much? She probably doesn't care disclosing because she's attitude measured out, you're 240, right? Maybe 120 pounds, maybe 15 with a uniform on. Now, is the level of force that we can use given the subject is the same and what they're doing is the same, is that level of force different? It most certainly is. She can legally step up her use of force quicker because she is smaller in stature, and what the scientific world tells us is generally women are not quite as strong as males. So she can step up her use of physical force much quicker. Let's talk about another situation. Let's say a law enforcement officer has somebody stopped on the side of 240, and it turns into a physical altercation. The person's fighting with the officer. Because there's rush hour traffic going on, can that officer step up their use of force quicker to control that situation because of the surrounding? They can't. Another situation. Subject's doing the same thing, has the same weapon or no weapon or whatever, but they're conducting the same type of activity or putting the same effort into avoiding an arrest. And there's 3 officers instead of 1 officer. Can those 3 officers use the same amount of force that 1 officer would be able to use? No. Okay? Unless it turns into a deadly force type situation, and immediacy of action is called upon. Now, honestly, do we always get it right every time? No. Do we, a lot of times, get it within what the statute allows? Generally, we do. Sometimes we have officers that way overstep the boundaries, and they're held responsible for that, not only civilly, but criminally. In today's world, in most cases, there's generally a video, there's film footage, there's witnesses, there's things that will come to bear to where people who have to sit back after that and decide upon appropriate uses of force get a lot more to view in the way of evidence and descriptors as to what happened than they used to did. So it becomes a little easier. Still a tough thing to work through and put yourself in the officer's role and say, is that what a reasonable officer would have done? Evaluating tactics by control versus injury. You know, and in all honesty, and I'm not trying, because this is a very sensitive subject, and I don't want to even sound like I'm being flip about it, but is a baseball bat a good defensive tactic tool? Yeah, pretty good. Causes a huge amount of injury. So does that make it a good tool for law enforcement? Absolutely not. We want something that offers a great amount of control with very little chance of injury. Next slide. Now, let's talk a little bit about ability, opportunity, and intent. For an officer to step up and use deadly force, the person that they are using that force on has to have these three things going on that a reasonable officer would believe was present at the time. Number one, they have to have the ability or the capacity to carry out the action. So if you get somebody that steps up and says, I'm going to kill you, Officer Smith, and they're standing there open-handed and a reasonable amount of distance away from the officer, but they have no means or ability to carry that threat out, can the officer step up and use deadly force? Absolutely not. But let's say they have a weapon, okay? And you guys have seen a lot of interactions between police and law enforcement and members of the public who may have a weapon. Do they immediately shoot that individual? No. Because you got a couple of other things that have to come into play. Number two, the subject must be in the position to carry that act out. So if they have a weapon and they're not necessarily pointing it and there's nothing else by their behavior, which we're getting over to intent now, but nothing that would lead that officer to believe that they're trying to present a threat, then they're probably not going to use deadly force at that point in time, okay? But a better example of that is a knife, is an edged weapon. If you're an officer and you're standing at the door and I'm here with a butcher knife and I say, I'm going to kill you, that officer is probably not in the position to where they should use deadly force there. But when I get within position to where I have a weapon that has the ability to do serious bodily injury or death, then that officer may step into that arena to where they can use deadly force. And remember, all the time when commands are going on and somebody's telling somebody, drop the knife, turn around, stop what you're doing, don't come any closer, and they have the means, they're getting close to deliver the opportunity, and by their actions, they're also showing the intent to do deadly force. An officer's justified by North Carolina law at that point in time to use deadly force. We look a lot of times at a subject's mental state, the reason for the call, why we're there in the first place, what they've done leading up to that. All those things are relevant until that officer making that decision whether that person's showing the intent. So they've got to have the ability, they've got to have the opportunity, and there should be some kind of measurable intent for that officer to step up to deadly force. Next slide. Okay, we're going to get into some actual shootings here, and probably the most important part of the presentation. A lot of people think that, and I had questions, and the questions are perfectly fine, because if you really don't understand and your familiarity with a gunfight is what you see on TV, then these questions are very reasonable. Like, shouldn't the officer have shot the person in the leg? Shouldn't you train them to shoot them in the leg? Shouldn't you train them to shoot the gun out of their hand? And that's actually happened at times. But remember, gunfights are extremely dynamic events. They occur in quarter-second time or second time. There's very little time to do a lot of things other than to respond the way the person's trained. Handguns primarily are very ineffective for immediate incapacitation of an individual presenting a deadly threat. And what that means is, generally, a lot of times they have no observable effect on the individual who's just been shot, even if they've been shot and received a wound that is non-survivable. I'm getting ready to show you that. Actually, every one of these cases that I pulled, you're going to see that happen in every scenario. That's not the exception to the rule, that is the rule. The exception to the rule is if somebody gets shot in an area that disrupts them neurologically, which is kind of the head and the spinal cord area. Generally, if one of those areas is not struck directly by a projectile, a lot of times you can't even tell that individual's been shot. And that's what you're getting ready to see in this case. I'm trying to remember, and I'll get a little confused. Do you remember, is this Wisconsin? Where is this, Natalie? It's Wisconsin. We got one from Wisconsin and one from Ohio. What you're going to see here is a traffic stop. The officer is stopping the individual for speeding. A couple things I'm going to tell you. I don't know much about the subject's background. He gets out in full fatigues. He is non-compliant to verbal commands. He has his kids in the back of the car. One of them's in a car seat. The other was toddler age. This individual gets, and I think we've got sound. I hope we do. This individual is shot when you hear the first round go off. And he's hit center torso, non-survivable wound. He's giving him commands. He disregards. He's non-compliant. He moves forward in an aggressive stance. He can't see if he has a gun or not. He's shot right there. When you see him do this, he has suffered a non-survivable wound. He actually shot the officer after that point in time. What you see him do is he moved around the car. He accidentally hit the magazine release on the pistol and dropped his magazine on the ground. The pistol will still fire one time, depending on what kind of pistol it is. His would have. He stops, he picks the magazine up, he reinserts it, runs back around, and instead of advancing on the officer, decides to get back in the car, which his two kids are in, and he drives 1.5 miles down the road, and they find him parked on the side of the road, deceased from the one gunshot wound he suffered when the gunfight started. He shot the officer after that point in time. And you might say, well, Sheriff, you can pick those out. You can, if you go and you surf through, you can find things and pick out that demonstrate your point. These things are really easy to find. If you go on YouTube, and I'd highly recommend you do that, you'll see officers that don't use force appropriately. You'll see things that are not reasonable uses of force. But as you watch through these things, what you will see is the commonality is handguns are very ineffective in a gunfight for immediate capacitation. And let me answer another question that's probably going to come up. Are we taught to shoot to kill? No. We never discuss shooting to kill on a firearms range. When we train, we talk about shooting to stop a threat. To stop that threat, which is the reason why you're using force to begin with against the officer or a third person. Okay, Miami-Dade shootout. Let me prep this one a little bit for you since you can't hear it real well. Go ahead and start rolling it, Natalie. And you've got DEA officers and some of the local law enforcement, and they're going to go back and show it right here in a minute. That's the subject behind the tree right there. He eventually ends up getting killed. They cut this short. There's a full film of this on YouTube. I encourage you to go find it. They finally end the gunfight because one of the officers took a supported position behind the car and ended up shooting the guy in the head, and it stopped the gunfight. He got shot several times and continued to shoot and wound officers after he was shot. What happened is they roll into a drug house to serve a search warrant, and they miss the fact that this guy, that's the guy that's in the shootout, he's getting in his BMW, and they miss the fact that he's on scene. He's got into the car, the officers arrive, they walk past him, they never realize he's in the car. This is before the officers get there. He's in the car now. All the officers walk past him, they're paying no attention to him. As the officers start effecting the arrest, he gets out with a handgun. This individual is shot. He's already been wounded here multiple times. He's hit center torso, non-survivable wound.
Please sit back in the car for me.
3 times after he had already.
You were speeding, but right now I need you to... Sir, get back in the car for me now.
Law enforcement has some...
Please get back in the car for me now. I told you you were speeding.
Forward and aggressive stance. Shot right there. One of them was 1986, the Miami-Dade shootout. Most of you are old enough to remember, very few of you are old enough to remember the 1986 Miami shootout, but most of you remember the North Hollywood Hill shootout. What you see him do is he moved body armors and robbed the bank. He accidentally hit the magazine shootout in Los Angeles, which changed a lot about armor and fire.
5326 shot fired.
In 1986, the two guys picks the magazine up, reinserts it, runs back back of automatics, and instead of advancing on the onslaught, and they would get the people out. Sometimes they would execute the car driver down the road. They actually killed a 16-year-old kid that was on the Tamarani Trail in Florida that was shooting, and they were in his car when the felony takedown occurred with the FBI's team that was working that area. They were on US 1 looking for this car, looking for a particular license plate. They were in this young man's car, whom I don't think they had found deceased at that point in time, but they knew these guys were in this Monte Carlo. They initiated a felony vehicle stop. I think there were 9 FBI agents, most of them armed, one armed with a shotgun, the rest armed with handguns. Michael Platt was armed with a .223 rifle, what law enforcement and military commonly carry. The other guy was armed with a shotgun. Both of them had handguns. They actually crashed the vehicle into a curb in a parking lot, and a gunfight ensued. Michael Platt gets out of the vehicle, gets shot under the arm through the thoracic cavity with a 9mm silver tip. It goes almost all the way through. The the Miami-Dade medical examiner said that was a non-survivable wound. If he would have laid down right there and they would have got him a medical attention, he would not have survived that wound. He got back up, continued to fight on, killed 2 of the FBI agents, including the one who had shot him, and wounded 3 to 4 or 5 others. So those are the kind of the dynamics of a gunfight. Next tape. This one, if we had the sound, is particularly disturbing in that this individual was, they found out later, the officers that were stopping him got to be on the lookout for the vehicle. There was something about shots fired. They didn't have complete information, but they stopped this vehicle. They kind of keep a distance, trying to figure out what the situation is. The driver of the vehicle, they found out later, was pretty much a threat, and he was going to do the suicide by cop thing and make law enforcement shoot him. One of the officers, this is a 2-person vehicle, 1 male, 1 female officer in the car. They'll see and recognize the vehicle in question. The resolution on this tape is not really good. If you go back and watch it on YouTube, once again, I encourage you to pull it up and look at it in detail. When this car door opens, one of the first things you see is the barrel of a rifle coming out. That particular weapon is a AK-47 variant, semi-automatic. It shoots a .30 caliber bullet. That there's nothing in that car that will stop it except a steel wheel and an engine block. It will shoot through a vehicle. If we had, you can barely hear it, but the 2 officers are talking about what they're going to do. They get information from dispatch. It says he's been involved in a shots fired call, this particular vehicle. He gets shot right there for the first time. He's screaming at the officers to kill him. He's still continuing to shoot. One of the officers has been hit, the passenger. He goes down, he's trying to reload. The officer reloads and finishes the event. Like I say, when you go in and watch these actual events, you watch people's initial reaction to being shot with a handgun. Most of the time you can't even tell they've been shot. You have to go back and really look and see. There's generally some type of reaction, but it's certainly not incapacitation. And they continue on to fire weapons, run towards officers, and do those type of things. Okay, next slide. Now, here's really what happens. Thank goodness that those type of shootouts, those first 3 we showed you, that's not the norm of really dangerous interactions with law enforcement and people who are violently resisting to being arrested. This is more the norm. You get a guy, comes in, I forget what time, I think this is a government building, courthouse, something. He comes in highly agitated. They find out later that he's tweaking, he's on some methamphetamine. This is two angles they show this particular event from. You're going to see an officer come in from the bottom of the screen and engage him, start trying to talk with him. You can tell the guy's very agitated. As the officer comes up and tries to talk to him, the guy steps forward, punches the officer, they go down. Now they're going to show from a different camera angle, and you can see a whole lot more of what happens. Same event, just from a different angle. The guy starts to have a little conflict with this guy coming out. The officers are somewhere see and hear what's going on. They come out, they start to talk to this individual. Now there's three officers there. This guy tries to punch the officer. Right here, he gets this officer's handgun. You see that Glock clearly in his hand as he goes back. He's able to reach up when they try to take him to the ground. He gets the officer's gun out of the holster, falls back. At this point in time, they could have used deadly force. Kind of tough to do, but they're in a position to where they can grab hold of the gun, control it. That's what they choose to do. You see officers reholstering. They get the guy under control, get control of the gun back, and place him under arrest. Now, here's the thing. Once they take that threat away, when you look at that ability, opportunity, and intent, once that's out of play, they have to step down the use of force, okay? They can't stay at that use of force once the threat's no longer there, and they know that. They can't keep up with that use of force. So you see them on top of that person. A lot of folks who might look at this and say, well, gosh, four of them are on top of him, but you see, nobody's striking him. Each one's controlling a limb. Their goal is to get him into handcuffs. And with somebody that is very actively physically resisting, it's pretty tough to get those arms into the position to get them handcuffed. And my point with that is if it were one officer instead of 1, 2, 3, 4, 5, 6, 7, now you have 7, that one officer would be at a very high level use of force with an agitated person that's already taken one officer's gun. He's shown the intent that he's willing to use deadly force on the officers. So that's, as officers move in, the amount of force they can use lessens. All right, next slide. When force is used, we have to fill out a use of force. My officers have to fill out, and the chiefs the same way. They have to fill out a use of force report. So in other words, if they go out here and use their taser, or they strike an individual, or they spray somebody with OC spray, they have to fill out that use of force. If they go past the point of soft, empty hand control, they are having to fill out an internal use of force report that gets reviewed by that sergeant at the end of shift and goes on to the patrol captain, which he reviews. And I'm going to be very honest with you. We have those things reviewed. Generally, there's no problem with it. We've had a couple of situations where the captain looked and said, you might have been operating under statute, but you could have done better than this. And we actually had a couple that got sent back through training. They didn't violate policy, and they acted under statute, but they had other means available. If we ever get to a point, actually we encourage our officers, if it's a physical altercation, before they get into a fist fight, which that's how most of us growing up were taught how to deal with physical altercations, right? I mean, we get that from the schoolyard up, and it's kind of a natural tendency. You do what you're trained or what you're familiar to do. But what we do with law enforcement officers is we highly encourage them to stay away from that and go to a taser or OC spray. Why? Injury versus control. Generally, to control somebody that's mad and aggressive, to get them into handcuffs from physically hitting them, there's going to be some injury there, and we want to avoid that if at all possible. So those reports come up, whether it's the detention center or whether it's on patrol or they're out on civil process. If an officer uses force more than soft, empty hands, that report is done. We have had internal investigations launched both from members of our department because they saw something that wasn't correct, and from members of the public. So don't think that if we see something that happens and an officer's outside that use of force, that we're just going to wait around till the public comes in and reports it. Now, if you saw it, by all means, and it didn't look correct, and you think there's something by the nature of what you saw that this was just out of hand, you need to report that. And we most certainly will look into it. At the end of the day, because of the training and what we see on the film, and we evaluate, our policies, what the officer did, was it reasonable? Is it how we train them? What they did might have been okay. Then again, it might not have. And I can assure you that the last thing that myself or the chief wants is an officer who is out here acting outside of reasonableness and trying to hurt people. That's just a ticking time bomb that's going to blow up, and it gets all over everybody. So when we're able to identify those folks, we move them into another career. But it is also our job, if an officer is acting under statute, acting by law, and we have some pretty drastic outcomes, if the officer was acting under that in good faith and reasonableness, it's our job to support that officer and support what happened. Because we still have all those other officers that are responding to calls out there every day that they don't have the option not to go. They have to show up. People with guns, shots fired calls, those sorts of things. So I'm not going to say it's a fine line. After you do this for a while and you kind of look at it, the right thing becomes pretty clear after a while. Probably what we don't do as well as we should on the law enforcement end is do this kind of thing, is communicate with folks so they understand the dynamics, what the situation is, and if it's a case that's still waiting to go to court, a lot of times we can't get into real specifics. We would be wrong for doing that because you've got to have a jury pool that they can get that's not influenced by what they see or read in the newspaper. External investigations. Anytime that we have something that there is a indication of wrongdoing, and that can be different things. Now, a deadly use of force, we're calling the SBI. I'm calling the SBI every time. I don't know if you guys realize it or not, but we're not obligated by law to do that. There is nothing in North Carolina statute that requires us to call in a third party to investigate a deadly use of force confrontation. Is it a best practice? Yes. Do bigger agencies do it? Charlotte-Mecklenburg does not. They do their own internal investigations, even on deadly use of force shootings. So we call in the SBI. The SBI comes in. They investigate. They turn their findings over to the district attorney. The district attorney looks at it as far as whether or not they find probable cause that officer should be charged. We deal with it. We run a concurrent investigation within the department because the SBI is not going to come back. They may come back and say, your officer acted under statute, because they're not looking at the policies and procedures of the agency. They're looking at North Carolina law. Did they act under North Carolina law? And that's all they're going to say. So to be responsible on our end, we look at it, did that officer act by policy and procedure? Did they use the best option available? If they didn't, was it something that we can train, that we need to pay a particular attention to be able to fix that? And Lucy is telling me I'm out of time. I hope I didn't eat too much up. But this is one of those things that can go for 30, 40 minutes, or we could discuss this for an hour and a half with questions. But we're going to hold questions to the end. Thank you, ma'am.
Go ahead, ma'am. Absolutely, and please know as well that, that was sort of what was mentioned in the beginning, that ABCRC sort of helps to navigate that process. So we will have information out there, so if you need to contact us directly. Okay, absolutely. So what we're going to do, and we agree, thank you, Sheriff, and we also agree that this should be, we're hoping that this is just the first of multiple conversations because it's super important. We want to have Chief William Anderson come up and say a few words, then we'll have local civil rights attorney Frank Goldsmith come and say a few words, and we'll move right on into our Q&A session and comments. Thanks.
Thank you, Lucia. Good evening. Good evening. First of all, let me say it's a pleasure to be here. I want to thank the Asheville-Buncombe County Community Relations Council for hosting this forum. Just like the sheriff, just to give you a little bit about my background, I've been in law enforcement for 37 years. That's why you see all the gray hair that comes along with it. And in 2 weeks, I will be celebrating my 15th anniversary as a chief of police. So I've been around for a little while when it comes to this. And I do think the issue of use of force in law enforcement is very important. And I think it's very important that we educate the public. What I wanted to do tonight was kind of take a little different approach. The sheriff has done a great job as far as educating about the use of force, about how law enforcement utilizes it, the training, the law itself, and that sort of thing. But the approach that I like to take is, how can we educate our young folks so that this does not apply? How do we educate our young folks so that we don't get into situations where law enforcement has to use, there has to be a use of force, or there has to be some type of deadly encounter? And when I look around this room, and I'll just be honest about it, this is not the audience, okay? I really don't think many of you in here is going to have to worry about an encounter with law enforcement. When I look around this room, this is not the audience. The audience that we need to be connecting to is our young audience, our young folks. And my law enforcement friends in here, they always get mad with me when I say this. But there is a high probability that if you are a young person, you're going to have an encounter with law enforcement, especially if you're a person of color. So when I look around this room, I don't see many folk in here that has to worry about that. The folks that we need to be educating, and what I'll do with my presentation, what I'll ask you to do, is take this message back to our young folks, because they're the ones who are most likely going to have these encounters. And when we have these encounters with law enforcement, it does not mean that the police department or the sheriff's department has made a mistake or not doing their job. It does not mean that anyone is being racially profiled or profiled in any kind of way. But the probability of a young person being stopped by law enforcement is a reality. And not just in Asheville, across this country. Our jails, our prisons are made up of who? The high number of people that are in prison and in jail are made up of who? Exactly. Well, I'm not going to say innocent people, but I will say that there's a high probability that there's young folks that are in jail. And what we need to do is best do we can to educate our young people how not to be involved and get involved in some of these encounters. We have to help them understand that it's important to make good choices. A lot of things that happen, a lot of situations where we do have these encounters with law enforcement is a direct result of bad choices, people making bad choices. And again, what I think we need to do is better educate, better train, and better teach our young folks how to deal with some of these encounters when they come up. What to do if you're stopped by the police? What happens if you're stopped by the police? How do you react? How do you put yourself in a position where you're not dealing with a use of force situation? How you avoid all type of situations where it's a win-win situation, where it's a encounter that maybe nobody goes to jail and especially nobody gets hurt. And again, we have to make sure that we teach our folks to make good choices. We want to teach them to avoid any type of confrontation. If you are stopped by the police, if you do have a situation, how do you avoid that confrontation? How do you get this not to turn into a bad situation? And one of the first ways is knowing your rights. And I know Mr. Goldsmith is going to talk about that. Knowing what your rights are. Knowing what to do if you are stopped by the police. And 3 basic rules that I think we need to instill and talk a lot about. Number 1 is show respect. If you all are stopped by the police, one of the first things you do is show respect. The second thing to do is cooperate. If the police officer or the sheriff's deputy or the highway patrol trooper, if they have a question, they're asking you something that's going on, cooperate. Answer their question and be honest about it. Because you don't want to be put in a situation where you're being untruthful, you're being evasive, or you're trying to possibly get out of a situation that could only be made worse. So it's very important, number 1, that you show respect, cooperate, and be honest. What do you do if you're driving? And again, I don't think this is a big issue for this audience, but what do we tell our young folks if they are stopped by the police, if they're driving a car? What do we want them to focus on? Number 1, if you're stopped and you see the blue lights, slow down. Stay in the driver's seat and keep both hands in sight so the officer can see exactly what's going on. Listen and comply with the officer's request. Do not speak rudely. And remember, police officers are human too. They're going to make mistakes. They may have had a bad day, and we want to make sure we don't do anything to make the situation even worse. So these are all techniques. These are all things that we need to try to remember. And on the other side of that, these are things that we have to teach our police officers. Because even if they have had a bad day, or even if there has been a bad situation, they still have to remain professional. They still have to do their jobs. They still have to treat people with respect and as a human being. These are the values that we try to instill in all of our police officers so we don't have some of these issues. If you ask for your driver's license and registration, produce it. Most police officers, when they stop you, and you may say, what are you stopping me for? You start asking questions. They're really not going to answer that question until they have your driver's license and registration in hand. Now, what's the reason for that? They want to know who they're dealing with. They want to know who the person are and make sure that you have the proper documents before it goes even further. So comply, cooperate. And again, I don't think we'll have any issues with any folks in this room, but this is the message we need to send to our young folks. Every opportunity that we get to talk to those who there's a high probability of being stopped or having an encounter, we need to make sure that the message is getting to them. Because we have too many of these situations. We have too many. How many of you saw the police officers on your way here, the blue lights, and as you were coming in? You know what that was about? Somebody ran from the police. It was a traffic stop. They decided they didn't want to cooperate, so they jumped out and ran. So next thing you know, we got 10 or 15 cop cars flying through the neighborhood trying to catch this individual, putting not only himself in danger, but putting all of us in danger as well, because we're trying to do our jobs. We're trying to catch an individual who fled from us. But is that something we can learn from? Once this individual is apprehended, and he will be because we know who he is it a way that we can change his behavior? Is it a way that we can talk to this person and help him out or help some others out so that we don't run into these type of situations? It's education. That's how I think we can make our streets safer. What if you're walking down the street and you're stopped by the police? How many of you have had that happen? Come on now. I mean, you're walking down the street and you're stopped by the police. Nobody has. But I guarantee you, if the audience was different, there'll be a lot of hands going up in here. I guarantee you we can walk across the street right now and ask the same question. There's a lot of hands that will be going up. How can we educate these young folks not to get in these type of situations? If you are stopped by the police, what do? Cooperate. Don't run. Don't give the officer a hard time. Don't cuss them out, because things might not go the way that you want. We need to work with our young people, and I'm going to keep saying that because that's the message that we need to send. This group is fine. This audience is fine, but we need to be having this message in Hillcrest. We need to be having this message in Piscataway. We need to be having this message in Livingston, Lee Walker Heights, and some of the other areas where we know that there's problems and we know that these encounters happen. That's the educational piece that I think we must focus on. But if you are stopped while walking by the police, answer the questions that the officer may have, dispel any suspicion that he or she might have as to what you're doing, why you're doing whatever they think you're doing, so that everybody can have a peaceful situation. Because what happens when it doesn't work out that way, then we're talking about all of this. Then we're talking about use of force. Then we're talking about handcuffs. Then we're talking about jail. Then we're talking about prison time. And you know what else we're talking about? Bad community relations. Because it's an issue. Those are the things that we need to focus on. Now, police officers aren't perfect. We're going to make mistakes. There's going to be situations that need to be investigated. The police department, the sheriff's department, is no different than corporate America or any other business. We got some bad apples too. And we got some folks that don't do some of the things that they need to be doing. But as the sheriff mentioned, and I think he said this, that's our responsibility. That's his responsibility, and that's my responsibility to make sure that we weed out the bad apples. So when things happen, when you feel that you've been mistreated, when you feel that the police officer acted inappropriately, you got to report it. You got to let us know. I can't fix anything that I don't know about. I can't deal with it if it's not brought to my attention. And there's so much information out there. There's so ways of gathering information that it has to be utilized. But when you feel, and you pass this message on, when you feel that we have not done our jobs, when you feel that we have acted outside our lines, when you feel that we have abused our powers, it has to be investigated. We have to get to the bottom of it. I want to know, because I don't want any bad apples on my police department. I don't want anybody who's not doing their job in a professional way. I don't want anybody to misrepresent the APD. And I know we have history. I know it exists. I know there's issues within our community when it comes to relationships and things like that, but what we have to do is work together to figure out how we're going to heal those relationships, how we're going to work together, share information, and make sure that we're all on the same page. So if and when something happens and there is that encounter, we can feel comfortable that it's going to be handled in a professional manner, that things are going to be worked and handled the way that they should be. I'm very proud of my police department. I'm very proud of our police department and what we do, but it's imperative that I do my job to make sure that things are handled appropriately, that there's an investigation done when there's an allegation made, and there's some outcome. Every internal investigation, every complaint that comes into the Asheville Police Department, citizen complaint, crosses my desk. That's the last place it stops. And my job is to make sure that there's a complete and thorough investigation done, and in the end result, that there's an outcome and that you've notified of that outcome. Now, because it deals with personnel issues, we normally can't tell you a lot unless it deals with a demotion, suspension, or termination. Anything less than that, personnel laws does not require us, or does not allow us to discuss those things unless it's those three things that can be made public. But my message today, and I'll close, I want to thank the sheriff and Mr. Goldsmith for being here, and I most importantly want to thank all of you for being here. But my message today is simple. let's stop the craziness. Let's make sure we communicate to our young folks. Let's make sure they understand their rights and know what their obligations are. Let's make sure they know how to handle situations and make good decisions. We don't ever, at least speaking for myself, and I think I can speak for most police officers, we don't ever want to have to use force in any situation. That's not what we are about. That's not what we should be about. But it happens, and it happens all too often. So what we need to make sure is that we do everything we can to educate the public, especially our young folks, to help them get to that next stage so they don't make bad choices and things happen. So again, thank you for having me. Hopefully the information was helpful, but we need to be having these type of meetings in other settings. We need to be having these type of meetings where the audience are the ones that truly, truly need to hear this. But again, thank you for being here.
Thank you so much, Chief Anderson. I keep finding this recurring theme of multiple conversations. I know I've said it a few times. And lastly, we'll have local civil rights attorney, Mr. Frank Goldsmith.
Thank you very much. I'm really honored to be able to share the program tonight with Sheriff Duncan and Chief Anderson. If you came here thinking there would be a debate between the civil rights attorney and the officers, you'll be disappointed, because I didn't hear anything that either of these men said that I really disagree with. But I do want to give you a different perspective, and that is the perspective of a civil rights lawyer. I am now mostly a mediator, by the way, but most of my career has been spent in a law practice that largely included civil rights law. And I want to tell you that that doesn't mean that I have always been on the other side of law enforcement in those cases. My firm has had the honor of representing the Fraternal Order of the Police in the county where my office is located, McDowell County. I've represented a lot of individual officers in various actions, some against their own departments when their rights were violated. But I've also represented a large number of citizens across all of Western North Carolina when they have made the accusation that their civil rights were violated. And what I have learned in 40-some years of legal practice in that arena, and I think what most other attorneys who handle these cases would tell you, is that civil rights cases are some of the most challenging cases that an attorney can handle. The law is extremely complex. The law is constantly in a state of evolution, and it really is hard to keep up with it. And so I'll touch on just a few of the points that will illustrate why that is so. For one thing, when we deal with civil rights cases, we're really talking about two different sets of laws. First, we're talking about state law. And in this case, as Sheriff Duncan went through, we have North Carolina General Statute 15A-401 that sets out the instances in which force can be used by an officer. And Sheriff Duncan laid that out very well. That statute breaks it down into just plain force, which can be used to effect an arrest unless the officer knows that the arrest is unjustified, and that's, talk about a hard burden of proof, that's very hard to prove. And it can be used to prevent the escape from custody or the refusal to submit to an arrest where there's probable cause, and the officer can use force, not deadly force yet, to effect that arrest. And then the statute goes on to talk about when deadly force can be used. And deadly force basically can only be used when there is a threat of deadly force on the other side. So, as the sheriff talked about, if there's an unarmed subject or a subject that is presenting something less than deadly physical force, then deadly force cannot be used on that subject. So we have that aspect of state law, that statute that governs the situation under state law. But we also have federal law, because the United States Constitution says in the Fourth Amendment that unreasonable searches and seizures are prohibited. And you may think that that applies only to a search of somebody's property and a seizure of that property. But the courts have ruled that the word seizure also applies to the situation where somebody is, where force is used in effecting an arrest in the first place. There's a different standard if the person has already been convicted of a crime. That's the Eighth Amendment against cruel and unusual punishment. And there's a greater burden. You have to show that the officer used deliberate indifference to the near certainty that injury was going to occur. But with respect to the authority to arrest and the use of force in arrest, under federal law, it is a different standard. It is a standard governed by the Fourth Amendment, and since it talks about reasonable searches and seizures, the courts have held that it is a standard of reasonableness. And the standard is one of objective reasonableness. The courts have said that a court reviewing the conduct of the officer has to put the court in the position, you have to look at it from the position of the officer in that situation, taking into consideration the whole totality of the circumstances, the severity of the crime, the severity of the threat posed by the subject's submission to arrest or attempt to flee from arrest, and so on. There are a number of factors. One of the factors, by the way, is the severity of the injuries that were sustained by the subject in the arrest. But all of those are taken into consideration by the court in judging whether the officer used excessive force or not. And the courts have said often that you don't judge this by 20/20 hindsight, that you have to view it from the perspective of a reasonable officer in that situation. The officer's own subjective intent, the officer's bias, is not relevant to that determination. Now, that the officer's bias, the officer's subjective intent, the officer's motivation is fair game for cross-examination of the officer and may impact the officer's credibility as a witness and whether the officer's version is going to be believed. But the motivation of the officer, the intent of the officer, is really not relevant under federal law in judging whether or not excessive force has been used. The courts have also said that there are a lot of defenses that are available to officers. And that's one reason why, if you complain that you've been mistreated by an officer and you go to an attorney's office and the attorney is one familiar with this law, that attorney is going to ask you an awful lot of questions to find out if you have a really good case or not. Because the attorney knows, or should know, that there are a number of defenses available to police departments or sheriff's departments or to individual officers who are sued. And that is a complex subject. I'm not going to get into the details of it, but it depends on the capacity in which the officer is sued. Is it a suit in the officer's official capacity? That really amounts to a suit against the officer's employer, the police department or their sheriff. And there are immunities such as qualified immunity that basically says an officer gets one free bite of the apple, more or less, unless the officer can be shown that he should have been aware of a specific case that made the officer's conduct illegal, then the officer is immune for suit for that conduct. There is also public officer immunity, which is different. This is a state-created immunity. And basically, an officer, unless that officer acts maliciously or outside the scope of the officer's authority, more than merely recklessly, although sometimes the case law indicates sometimes recklessness is enough, that is a defense to that officer. If the officer cannot be shown to have acted maliciously or outside the scope of his authority, then the officer is going to be immune. There is sovereign immunity that protects the employer, the sheriff's department, or sometimes the municipality. There is absolute immunity, by the way. It doesn't apply to officers, but it does apply to judicial officials and to district attorneys when they're acting within the scope of their office, and that's pretty broadly defined under the case law. They cannot be sued at all. It's not a qualified immunity situation. So the law is very complex, and what a lawyer will look for in judging a civil rights case as to whether it has merit are things like, was there probable cause to effect the arrest in the first place? If there's no probable cause to arrest, no force is justified. You can't use force. In fact, If there is no probable cause to arrest, the citizen being arrested has the right to use reasonable force to resist. Now, that's a calculation you better be very careful in making, unless you're really good at knowing the law of probable cause. But theoretically, you can use reasonable force. You can't use deadly force to resist an arrest, but you can use reasonable force to resist that arrest if there is no probable cause for it. I don't advise it, but that's the law. The other things lawyers would look for are indications of excessive force. The statute that Sheriff Duncan put on the board, 15A-401, in one of its sections, and actually the last section of the statute, says that nothing in this subdivision constitutes justification for willful, malicious, or criminally negligent conduct by any person, including an officer, which injures or endangers a person or property, nor shall it be construed to excuse or justify the use of unreasonable or excessive force. So perhaps the force was unreasonable or excessive. That is a case that a lawyer may pay attention to. If the subject was unarmed and deadly force is used against the subject, that's not lawful. I can give you an example of that right here from the city of Asheville, from a case that went up to the Court of Appeals about 2 years ago, in which a car was traveling through a neighborhood at a fairly low rate of speed. The person driving the car was known to be wanted by the police. There would have been probable cause, there was probable cause to arrest that person. But that person had a passenger in the car who was completely innocent. She was a passenger in the car. Those officers, in an effort to stop that car, this was not on Chief Anderson's watch, I will hasten to add, when this occurred, those officers fired a total of 27 bullets at that car. Now, Sheriff Duncan talked about how a handgun round is unlikely to be immediately incapacitating, and that is absolutely true, especially something like a 9mm round. The other part of using a handgun, though, is that it's hard to hit a target, and it's hard to train to hit a target under circumstances that mirror what you're faced with the adrenaline rush in a real combative situation. So of those 27 bullets that 3 officers fired at that car, 16 hit the car. We don't know where the others went, I guess. Well, maybe they do. Do you want to know how many hit the driver they were aiming at? 0. 2 of those rounds hit the passenger, who was innocent. So of the 27 rounds that were fired, 2 hit a person and not the person that was intended. It illustrates 2 things. It illustrates how handguns are not so great, perhaps, in that kind of situation. Sometimes it's all you got. But it also illustrates excessive force. The Court of Appeals of North Carolina said that because that car was traveling at a low rate of speed, 25 miles an hour, and because those officers knew that there was an innocent person in the car as a passenger, and because that car traveling at that speed in the manner that it was traveling posed no imminent threat right then and there to those officers, they were not justified in firing those rounds. They were not justified in using deadly force to try to stop that car. The use of deadly force to stop a convicted felon is one area, by the way, and of course that was not a convicted felon situation, is one area where state law and federal law differ. And so it's important to realize there are some areas where there are different standards and the law will conflict. North Carolina law states that a convicted felon can be stopped by the use of deadly force. Federal law says that's not true, that you still have to have the threat to the person using the deadly force. You have to have a threat of deadly force back to the officer. So that is one area where the law differs. It is another reason why this is such a complex topic. I'm not going to get into all the details because I really want to leave some time for your questions and answers tonight. But I just wanted to give you this overview of the state and federal considerations that come into play when you're talking about excessive force.
Thank you so much, Frank, for all of that really valuable information. Again, and I cannot reinforce this enough, when it comes to any sensitive topic in the community, real progress won't be made if you don't have 2 crucial components. One is education, which has very solidly and clearly been present tonight, but also dialogue.